Yeah, Monica, my question is, in Sabrimala case, secular principles were applied over a religious place, whereas here secular principles are to be applied on a secular place. Hence, can the ratio of Sabrimala case be applicable in the hijab case? And if yes, then what differences will it bring to the judgment?
Okay. See, okay. I have 5 minutes. I have time in this one. Okay. Now, if you see what were, see, always see the facts of a case and then we apply law on that matter. Facts of one case are different from the facts of the other case. So, as lawyers, we always say, and judges tell us, master the facts and then apply the law. We must master the facts. Now, what was Sabrimala case? Sabrimala case was that there was a Lord Ayappa temple in Sabrimala. There, the women from 10 years to 50 years of age, that is menstruating women, women in reproductive age, were not allowed. Women below 10 years of age, the girls were allowed. Above 50 years of age, the ladies were allowed. But this 10 to 50 years of age, women were not allowed. And why they were not allowed? It is said that Lord Ayappa is a brahmachari there. So he is there in celibate state of mind. So women of this reproductive age should not go there. This was challenged by a Delhi-based Indian Young Lawyers Association, a group of advocates, Delhi-based. They challenged it. And I think 5 judges bench judgment came, in which 4 male judges said yes, this is violation of women's right of equality, of liberty, of dignity. And hence they allowed and permitted women to enter Sabrimala. The lone dissenting judgment was that of the lady judge. Lady judge was Justice Indu Malhotra. She said, because of the peculiar facts of this case, if women are not allowed in Sabrimala, it's okay. It does not violate Article 14, 19, and 21. Now, peculiar facts which were pleaded and which were not at that time pleaded, but before the review came up, which were there all over, social media, and new facts were pleaded in the review petition. The facts were that there are thousands and thousands of temples of Hindus. In all the temples, women are allowed. Obviously, we go to all temples as women. Of Lord Ayappa also, there are more than 1,000 temples of Lord Ayappa. In all the 1,000 temples, women are allowed. I myself went to a temple of Lord Ayappa in Kerala and worshipped there. But there's only one temple out of these 1,000 Ayappa temples in which the women are not allowed. Because Lord Ayappa, he is in different avasthas in different temples. Somewhere he is a child, somewhere he is a married man, somewhere he is old, somewhere he is in Alagavastha. But here in Sabrimala, he is in the avastha of Brahmachari. And under Article 26, all the religious denominations have a right to regulate their temples. This was pleaded in the review also. And it was pleaded in the main case also. That Ayappans, that is devotees of Lord Ayappa, they form a separate religious denomination and hence they have rights under Article 26 to regulate the entry into their temples. It was said that all the idols in Hindu temples, they are juristic persons. They can be taxed. They are living entities, as in Ayodhya Judgement, Supreme Court held. They have the rights and they have the right to privacy also. It is the abode of Lord Ayappa, and he says in 999 temples you go, just one temple, in which there are rules and regulations for men also. The men coming there have to have 41 days of proper abstinence from all desires, from sexual activity, from pleasures. They have to sleep down. They can't dress properly. They have to grow their beard, etc., etc. So there are restrictions on men also, restrictions on women also. When all these things were pleaded during the case in Supreme Court, in social media, and in the review petition, all these things were pleaded that it is not about rights of women. They can go to 900 plus temples. It is about rights of the God in that avastha. And it was said that God in Hindu religion is a living entity and hence has rights. So, looking at all these points, the court said we refer it to a larger bench. In the review petition, the 5 judges with a majority judgment, they referred it to a 9 judges bench. And in 9 judges bench, they formulated a number of questions. There were, I think, about 7 questions formulated for consideration, chiefly aiming at, number 1, to what extent courts can interfere with the essential religious practices. Number 2, what about Article 26? How do you define constitutional morality? Then how do you define what is a religious denomination? Is Ayyappan a separate religious denomination and hence entitled to the protection of Article 26? So all these 7 questions were formulated. And उसमें है कोर्ट किस हद तक रिलीजन्स में इंटरफियर कर सकते हैं, बेसिकली इसके इर्द गिर्द. फिर उसमें there were a number of petitions which were also referred to this larger bench. Petitions involving, number 1, why Muslim women are not allowed in mosques. First writ petition. Second petition, the female genital mutilation among Daud Bohras. There is a sect in which there is female genital mutilation. Third, in the Parsi women, when Parsi women marries a non-Parsi, she can't enter her fire temple. She can't enter the Parsis' temples. That petition. So a number of such petitions which touch upon the main root, how much court can interfere in the religions. So all these petitions have been clubbed together. Now one hearing took place, but thereafter Corona came and the hearing has not taken place. So that is the essence and the thing of Sabrimala case. Yes. Vijay?
Thank you, ma'am, for such an insightful answer and for such a great comparative analysis. And